Hi there, everyone. My name is Orla Lehane. I am the Education Manager at AHEAD. I'm delighted to be joined here by Katie Ridge, BL. Katie is someone who has worked with us quite a lot in AHEAD on a number of law-related issues. And this evening we're talking about one in particular, that is the Web Directive, which has recently been transposed into Irish law. And we're aware that, very much aware at AHEAD, that this has implications for a number of our stakeholders, in particular those working in further education and training and in higher education. So what we wanted to do is just do a very quick introduction, a few short Q&As, questions and answers for you to hopefully clarify some of the questions that are coming up. So maybe to start, Katie, you could just tell us a little bit about the Web Directive and its transposition into Irish law.
Yeah, thanks, Orla. Thanks for inviting me to contribute on what is a really important development in EU and subsequently Irish law. As you've indicated, I suppose it's important for your stakeholders to understand there is a comprehensive account of all of this development as part of your resources. But in a snapshot, essentially we're talking about a piece of European law that's recognised as a directive, and that really means that the member states have a bit of latitude as to how they implement it, but there is a threshold of rights that they have to deliver in relation to the content of the directive. Now, this is a web accessibility directive, and essentially this has really been born out of a long journey within the EU amongst many stakeholders where they're trying to address the accessibility issues of people with disabilities and people who don't have disabilities in relation to a level playing pitch, as it were, in respect of accessibility of websites and apps. And essentially this directive, when implemented, required that all of the member states in relation to the public sector websites and applications, that they would have to implement and uphold and maintain a set of standards in relation to accessibility of websites and apps. So that's really, I suppose, what the directive is doing. And all directives come with a suite of timelines. And the timelines are given in order for the different member states to gather all their resources and implement the objectives. And it's, I suppose, important to say that all of the compliance timelines of the directive have now passed. So very clearly we're in the space where we as a member state and we as public sector service providers need to know what we're obligated to do under the provisions of the directive.
Okay, great. Thanks, Katie. And I know that one of the things we've been asked about a lot under the directive, organisations such as further education and training centres, further education providers, higher education institutes, and indeed other public sector bodies will have to have a web accessibility statement for their website. So maybe you could tell us a little bit about the web accessibility statement and what that entails.
Yeah, and again, it's nothing for your stakeholders to be afraid of. I think that many people would be familiar with the health and safety statement in the workplace. And that is something that workplaces have operated around since 1989. Hopefully this will become exactly the same kind of document. But what the directive and the transposing statutory instrument in Ireland requires is that all of the public sectors that are impacted by the regulations as they now are have to comply by having this somewhat detailed accessibility statement. And what this statement has to do, Orla, is it has to outline an explanation really for any inaccessible elements that may impact on the service user vis-a-vis the website or the application. And while it does that, and this is important in the practical delivery, I suppose, of equality out of the directive, is it has to inform the service user in relation to alternatives for access. There's also contingent in the accessibility statement guidelines on how service users can give feedback in relation to the educational provider, the public sector service provider, on how they have failed to meet the accessibility thresholds under the directive. And they can look for information in relation to whether the non-delivery is in fact an application or an element of a website that has been excluded from the directive, because we won't go into it for this presentation, but there are some activities that are excluded, and it's legitimate for an organisation not to have those available. But for the most part, this web accessibility statement is empowering people, because the third thread is the accessibility statement must provide a link to a complaints mechanism. So I think that those three strands together are actually giving a practical accessibility for end users.
That sounds great, actually, that people do have this ability to, you know, redress or find out where to go if there is an issue.
Yeah.
And like you said, that is an empowering thing for people. I know, Katie, we've had a lot of questions, you know, from teachers and educators around the online systems they would use when working with their learners. So could you tell us a little bit about the scope of the directive, maybe around learning management systems? I know teachers are very keen to understand a little bit more about that with regard to work that they might be uploading for their learners.
Absolutely. And obviously, since the lapsing of the implementation dates, the last one being the mobile applications just recently in June. So as I said, all of the requirements of the directive are now up and running. Many education services and the lecturers, teachers are very keen to know how they can provide the learning environment and be compliant with the directive. So I think what's important to say, first of all, is that the compliance is covered in a statutory instrument 358 of 2020. So if in doubt, the educational service provider should have recourse to that piece of legislation to signpost them in relation to their compliance. But in terms of the practicalities for any teacher or lecturer, what the directive is essentially driving at is that the learning management system is going to be accessible to the student. And I think there's 4 key principles that are embodied in the directive, and the acronym is POUR, so P-O-U-R, and that covers the principles of perceivability, that the learning resource is operable, that it's understandable, and that it's robust. So they're going, I think, to be very much the safety net of instructors, tutors, teachers, lecturers as they move forward. Now, in terms of the learning management system, essentially we're talking about, in Ireland, platforms maybe like Moodle or SharePoint, where educators are providing resources for increasingly, at the minute in any event, remote learning in many instances. And what people are looking for, I suppose, clarity around is, what may I do? What must I do? So I'd say the starting point is that if you have a learning management system that was published before the 23rd of September 2019, the regulations say that that learning management system is exempt until the website undergoes substantial revision. And that's the phrase that's used in the directive. Now, of course, unhelpfully or maybe helpfully, the regulations don't give us definitive definitions of what a substantial revision is. So I think on a reasonable interpretation of that requirement, uploading the occasional new document to your LMS platform wouldn't be considered a substantial revision. But I think that if there were many and multiple instances of uploading small changes, then the aggregate of that may amount to a substantial revision. So it would be important for learning centres to have some sense across the centre as to the amount of small revisions that are being done, so that they wouldn't fall foul, unbeknownst to themselves, in relation to, well, actually, we have moved into a space of a substantial revision. But again, to give comfort to your stakeholders, any of the small, occasional uploading of a new document, etc., is not going to attract the obligations under the directive. I think another comfort in terms of stakeholders would be in the arena of third-party plugins, social media, news feeds, etc. Very clearly in the directive and the implementing regulations, third-party content that isn't funded or developed by the public sector and that isn't under their control, essentially, is excluded from the provisions of the directive. So there isn't the level of accountability there in the same way where the resource is emanating from the service provider directly. Of course, one has to balance that with the principle of the spirit of this directive is not to exclude people in terms of our website content or our application content. So we need to be careful that the activity in that area isn't hindering real participation by service users. But in terms of accountability, I think that may become of some comfort to educational providers. And then I suppose the other common learning resource would be, of course, the live webinar or lecture. Now,
we've had a lot of questions about that, Katie.
Yeah, and that's even more prescient in the world of public health measures and social distancing, etc., because learning has pretty much moved out of the physical space at the moment. And even in terms of the developments around learning, it's very much a blended space that teachers and service users are in. So live lectures are specifically excluded from the scope of the directive. However, if we're going to record that and provide it as a resource, then the directive provides that within 14 days of us having that live lecture and us creating a recorded element of that, that essentially then turns it into a video, and the video is a resource that is covered by the directive. So one would need to be careful around captioning and other accessibility elements of that. So all in, I don't think it's too onerous. It's clearly going to engender more sharing in terms of the multiple disciplines and departments of teaching and education, even within a singular educational establishment, so that people don't fall foul involuntarily, as it were, because nobody wants to be the first institution that's cited as not compliant with the regulations.
Thanks, Katie. I think just during what you were saying there, you touched on it nicely, that this really is about accessibility and not putting barriers in place for people accessing this material in whatever form it takes online. Can I just follow up a little bit on the videos there? Because this is, again, it's something that we get asked a lot by teachers when they are preparing materials for their learners. So, for example, adding captions to videos. There are some automatically generated captions that are possible through a lot of programs now. But then there's a balance between maybe, say, getting professional captions that it might take a little bit longer, might be a little bit more costly. And, you know, as we're all increasingly using video in different ways at the moment, it can be hard to get captions from professional captioning organizations as quickly as one might like. Does the Web Accessibility Directive sort of, from a legal perspective, speak to this at all in terms of the, I suppose, the standard of the captions? We're aware that, you know, some of those that are automatically generated might not be of quite the same standard.
Well, I think the interesting thing about the directive is that when you go to look at the specifics of it, it actually signposts you to the Web Content Accessibility Guidelines. And these are really helpful guidelines from a technical perspective. So in terms of the IT support elements of learning institutions, and of course the user end of it, be it the lecturer or the student, the Web Content Accessibility Guidelines, we're in phase 2 and 2.1, and we will be moving into phase 2.2 presently. They give very clear standards in terms of what the directive is contemplating as acceptable. So there are 3 standards in it, and the AA standard would be the expected standard in relation to the public sector. Now, there is also the issue, and this is a feature in terms of many public service legislation that are prescriptive by nature. There is always the facility of what is referred to as the disproportionate burden defense. And again, you know, investing in the principle of the directive being the improvement of accessibility and therefore inclusivity for people using websites and applications. So bearing that in mind, there will be instances where an organization, a public sector body, looks at its resources and makes a determination that to facilitate a certain accommodation is beyond the means of the organization. And that is a legitimate legal argument or defense that a public sector provider can flag and raise. And I suppose the caveat is that where the argument is made that the entity doesn't have the sufficient resources, they have to be able to objectively justify with supporting evidence their inability. So that's obviously going to include what is the size of the entity, what is the resourcing that the entity has. So if it's getting state and other funding, clearly that's going to be a question that will have to be answered, together with the estimated costs and the benefits of the delivery of some additional feature in relation to the website or an application. So it's a legitimate argument to make, but it is one that the entity would want to be on firm ground in relation to the objective evidence that they can bring to support the rationale. It is something we would like to do, but we actually don't have the wherewithal to do it. And I suppose the other point to make in relation to the directive is the directive is another strand in relation to inclusivity and equality, because the directive is now sitting parallel with other existing pieces of legislation like the Disability Act or indeed the Equal Status Act. And the Equal Status Act in particular has always provided service users, including persons who have a disability, or indeed it could be on the age or any other ground, that reasonable accommodations are a feature in relation to the disability ground. So that is also an argument that the service user who's disappointed about them being unable to have the same sense of experience of a program of education or an element of a program of education, they could look to the Equal Status Act and say, I'm being directly or indirectly discriminated against because I'm not being accommodated in relation to my disability. So they may be able to use that act as well as an argument that the regulations are not being complied with. So each case is obviously going to be on its own merits, but I think that's something to be watchful for.
It's a good point. Thanks, Katie, that, you know, this web directive does sit among other, there is a bigger picture out there, whether that's among other legal requirements, but, you know, even also the whole approach to inclusivity and accessibility. So I know for us at AHEAD, you know, while this is one way of that goes towards improving accessibility, we have a wide variety of materials on our website and resources that we're going to be adding to really encourage people to take a holistic approach to this. And I think that what you've been telling us here right now should hopefully help people as well as they kind of navigate this new web directive and what it actually means for them. And I know you did touch on this already and why it's such an important thing to have this directive, but maybe even just to wrap up, you might like to say another few words about that.
I think that's what's really important and is a very progressive step in relation to the enactment of the transposing legislation and the directive in its own right, is that we've another step in the right direction in terms of this is making it more about the provision of the service in the first instance, the obligation of the educational providers, because that's the space we're talking about the directive in, but the obligation generally of public sector service providers to have it front and centre of their policy that there is equality and parity of access. We're moving away from legislation being necessary for people to fight for the entitlement. So on my interpretation of the directive, it's very front and center, empowering people because the policy must incorporate, for example, the accessibility statement. That makes it very real in terms of delivering equality of access, rather than it being maybe an older approach that required people to litigate in order to get the benefit of parity of access. So I think that that's the key thing. And by having raised expectations that people can practically access, then all boats are lifted on the tide in terms of accessibility being better and easier for everybody in a world that's becoming more and more technical and digitized. So it can only be a good thing. And the fact that people don't have to have deep pockets or confidence, or, you know, many people are inhibited in terms of litigation. And it shouldn't be necessary to litigate for a right. If it's enshrined in regulation, you should be able to access it as a matter of course. So I think it's very welcome development.
I think that's probably a great note to wind up this conversation on, that this is about being able to access the rights that we all have and should have as a matter of course. So a huge thank you, Katie, for taking the time to talk to me about the web directive. And I think your words will certainly have brought some clarity to many people who are you know, really trying their best to figure out how to make this work on a practical level. Just to note and reiterate, you know, there is a longer document available on the AHEAD website that does look at these legal implications in a bit more depth, that has very kindly also been put together by Katie, using her expertise in that area. So we're very grateful for your continued support in the work we do. And also this is one element of AHEAD's work around accessibility and web accessibility. We have a number of resources that we're continuing to produce across this year, and that's in addition to the resources that are already there on our website. So do have a look around. We are providing as much information and support around this as we can. As I said, this for us, this is one element of a holistic approach to accessibility and inclusion. So do have a look at the further resources that are there, and it is something that we will be continuing to discuss and provide further information on across this year. Thank you again, Katie, for your useful words of wisdom and insight this evening. Thank you very much.
Thank you, Orla.